Good morning. Welcome to the Court of Appeals. And your panel today is Chief Judge Donna Stroud. To my right, we have Judge Toby Hampson. To my left, Judge Fred Gore. And we have one case for argument today. Looks like y'all are all ready to go. And so this this is way down here. Okay. It looks like our chairs are not lined up with our microphones, so we're going to scoot. Okay. Is that better? Okay. Very good. Anyway, had you already set the time for the rebuttal? Okay. All right. Just want to make sure you had that. Was that 5 minutes? Okay. Very good. All right. Well, ready to go then.
May it please the court. My name is John Corella. I'm a member of the bar from Durham County, and I represent the appellant, whom I will refer to as Daniel, the pseudonym used in the briefs, and I do plan to reserve about 5 minutes for rebuttal. Although the criminal threats statute used in this case has been in force for around 5 years, this is the second time the state's prosecution of a child under the statute for words spoken at school has reached this court. If the state continues to pursue charges based on conjecture, it will certainly not be the last time. As the Fourth Circuit recently observed, a school shooting is an event that has become uniquely salient to the lives of American teenagers. And teenagers being teenagers, we can expect that some may say dumb and inappropriate things at school about a school shooting. The real question, and the test the state failed in this case, is when the state can make those comments the basis of a juvenile delinquency prosecution under the statute and the First Amendment. In the adjudication below, the trial court erred and violated Daniel's right to free speech when it found him delinquent, imprisoned him, and placed him on probation based solely on an isolated comment in a partially overheard conversation. The state failed to present evidence of further context that would show whether Daniel's words were a true threat or even a threat within the meaning of the statute.
So, counsel, what next step or furtherance would you hold the state to have to need to be able to make the words actionable by the state? Would we need the gun in a vehicle? Would we need a gun in a backpack? Would we need shots fired? Help me, give me a scenario where, based upon your argument, then it's okay.
Yeah.
Because the slope gets mighty slippery to where, and it's analogous to our government acting on, good intelligence. When do they stay asleep at the wheel? Or when do we take action to make sure that the unthinkable doesn't happen?
Thank you for that question. That's actually very helpful for how we can distinguish what's going on with this case from true threats and from other kinds of dangers.
Stop there.
Yeah.
Define true threat before you go into my other question, because you start dropping landmines and that Judge Moore wants to dig up and get out the way. So define true threat for Judge Moore. All
right. Well, let's dig into true threat. Okay, so when I speak about true threats, I'm talking about the standard under the First Amendment. And so I should say, since the last time this court visited this issue, there have been two controlling cases that have come down, State v. Taylor by the North Carolina Supreme Court, and in the middle of the briefing on this case, the Counterman decision. Okay, so let me lay out what I believe the law provides after those cases. First of all, the starting point is that criminal statutes that restrict speech based on its content are presumptively unconstitutional under the First Amendment. That shows up in Taylor, also R.A.V. v. St. Paul. However, criminal statutes are allowed for certain types of speech. Obscenity, defamation, true threats being one here, fighting words, a few narrow categories. And it's the government's burden to prove that there is a true threat within the meaning of this First Amendment law in order to proceed. Before Taylor and Counterman, there was a question as to how the state could meet its burden, whether it could just show that the statement was objectively threatening or whether it also had to prove some level of intent on the part of the speaker. Both cases gave a clear answer that the state must prove both. Must prove that the statement was objectively threatening and that there was some level of intent. They also both affirmed the standard from earlier cases like Watts versus United States, that in deciding whether something is a true threat, and I think this gets to some of what you're talking about, you have to look at the context. And there are a couple of specific factors that show up in Watts that are repeated in Taylor that I think the state and I both agree on here. One is the context in which the statement is made. Two is the nature of the language the defendant deployed. And third is the reaction of the listeners. These are the factors that came up in Watts and that are supposed to use in terms of judging the statement. The difference between Counterman and Taylor is the level of intent that needs to be proved on that second prong. So under all the cases, it needs to be objectively threatening and there needs to be some intent. What Counterman did that supersedes what the court said in Taylor, so is different from what I was arguing in the principal brief, is that the standard is a recklessness standard. That's what the Supreme Court set down. And what the state has to prove is the defendant consciously accepted a substantial risk of inflicting serious harm. In other words, the intent here, which is drawn from the court's defamation cases really, is that the defendant's intent is this conscious acceptance of risk. That it's not the specific purpose to threaten. And it's certainly, in none of these cases, is the question whether the threat will actually be carried out. The state does not have to provide evidence that the person was, in fact, going to follow through.
So I guess factors such as the context of the demeanor of the juvenile in this case when the statement was made, the following statements afterwards. So how do you address that in the transcript or in the record? There's some discussion in the trial court of there was no laughter or there was no kind of jovialness as far as and I don't think jovial was used, but in context of there wasn't a ha ha he he, using Judge Gore's words. There was no ha ha he he. Address the fact that there was no ha ha he he after the statement was made. That would help provide the context in which you're trying to frame your argument objectively.
Yes.
To say that it was a joke versus, oh, he meant that.
Yeah. And first, let me be clear here. Daniel does not need to prove that this was a joke. Okay, so the state needs to prove that.
However, I'm saying it would be harder for the state if there was a ha ha he he moment.
Right.
But
yes.
I don't see that in the record.
And there's a reason you don't see it in the record. And the reason you don't see it in the record is, well, because there is no direct testimony by any participant of the conversation as to what was said before, what was said after. None of the three witnesses even saw Daniel's face, could say what his expression was. I think you're referring to one witness's testimony that they didn't hear any laughter and they thought it was serious. That does not tell us whether it was serious or whether it was a joke. The state is essentially relying on speculation and conjecture here as to what was going on in this. You can contrast.
Is it your position that the only way to prove, I guess, really either the objective or subjective piece of this is to have the person who was being spoken to testify directly? It's not, I mean, here what you have are other students who, coming up on this conversation before class, overhearing this threat. Is it your testimony or your argument that that kind of testimony is sort of ipso facto insufficient?
Well, I think it depends on the nature of the testimony. This is a test of context. Okay, in this case, I think it is clearly insufficient because there's just simply not enough information. But I think maybe the easiest way to look at this is contrast it with the cases where courts like the U.S. Supreme Court has done this balancing. Okay, look at Watts versus United States. That was another one, a teenager, he was 18, engaging in a conversation on the mall in Washington, D.C. And he makes a statement, and he said a statement about shooting LBJ, like, you know, I'm going to get my sights on the president. Now, if that were like this case, maybe the state would have tried to proceed on the evidence of some bystander who overheard just that and nothing else. That would not be sufficient. What actually was presented in that state, in that case, was evidence by several witnesses, and they didn't all agree on exactly what was said. There was one government agent in there. I don't know that he was even directly speaking to any particular one of them, but they were there. They talked about his demeanor. They talked about what the conversation was that came before and what came after. And then it was clear that, oh, this is a comment on the draft. Okay? This is him stating his political opposition to LBJ in a crude and inappropriate way, but it did not rise to the level of true threat when taken in context. We have no context here. Not only were none of these 3 other students part of the conversation, they didn't directly overhear what was said. The only words that we have are not even directly quoted, but words like, something about, I want to shoot up the school, or I'm going to shoot up the school, and some other student saying something about bringing a gun. Now, you can also compare that to the last time this court heard one of these cases, which was in Ray ZP, and that there was some similar evidence that the juvenile in that case said something about bombing the school, and one of the students who was there said, I'll build the bomb. However, that student testified, and others testified, and it was clear that the student offering to help clearly thought it was a joke and didn't want to think it was serious.
But that sort of goes to the fundamental question here, right? As we struggle with these important constitutional issues and legal issues, there is a clear factual component and a clear factual determination that has to be made. And isn't that what the trial court's doing in weighing the evidence on a motion to dismiss in this case? And I mean, how much deference do we have to give the fact finder here in this court? I mean, and here the trial court made specific findings of fact in its adjudication order. Do we not, when it comes to issues like context and that sort of thing, how do we not have to defer to the fact finder?
Okay, well, ultimately, this question of how whether the context adds up to this being a true threat is a legal question, and this court is reviewing de novo the trial court's conclusion on that point. And also, in terms of factual findings, this court looks to whether they are supported or not. I believe there were 2 particular findings that we challenged, but they were mixed sort of findings and law. And I think that what we have to look at is you can go back to the standard on sufficiency of the evidence. It has to be more than a mere scintilla. It has to be more than suspicion or conjecture. The trial court, as the finder of fact in this case, or the jury in a criminal case, can't be left to guess whether this was a true threat, whether there was an objective.
But you would concede, though, that there's rarely, if ever, do we have direct evidence of subjective intent.
Absolutely,
And
but
that has to
rarely
be
we
drawn
do.
from the circumstances.
But here we have all these other cases that are cited in the briefs in which you can see where intent is found. Now, I've cited 2 in which they found there was no true threat, okay? And the state has cited several where there was a threat related to schools and bombings. And you can look at the evidence in those cases to see what kind of evidence would be presented. And again, it's not evidence from inside the mind of the speaker, as you would expect, and it's not always.
So if we don't have the evidence of inside the mind, well, obviously that would be the mens rea, then we use in other terms in the criminal context, actus reus. And so how do you address the issue specifically that there is a finding that the trial court found that in addressing the lack thereof of one context, laughter, joke, ha-ha,
Yes.
hee-hee, the trial court specifically made a finding that, that there was no evidence that there was any laughter or joking at the time the threat was made. So there's findings of fact by the trial court using the lack thereof
Yes.
to prove the actus reus, that there was no laughter, no joking, no ha-ha, hee-hee, emotion. So in that context, it appears the trial court is using the actus reus or the lack thereof of the actus reus to prove the context of the intent. Is that not arguable?
Well, I have no dispute really about the trial court saying there was no evidence of that, because there was no evidence put on. The question is, where does it go from there? Can you take the lack of evidence about context to conclude that something's a true threat, as opposed to evidence of context?
So what threshold of review, since there are findings of fact on that issue, and to go there next point, what threshold of review if it's there? Are we still?
Well, to the extent there's a finding an issue, and I would submit with that, what you've raised there, Judge Gore, is not an issue that I would take with a finding. I mean, the state has not put on evidence, and it was not Daniel's burden to put on evidence as to whether there was laughter. But there is not sufficient evidence from that to conclude that this was objectively or recklessly intended to be a threat.
So my understanding is that not disputing that finding of fact, but just arguing the sufficiency thereof.
Yes. Yeah,
And that helps me.
Well, especially for that sort of thing, I mean, given the evidence we have here, we have other students who heard the statements and testified about it and their reactions to it and how they perceived it. It seems to me a lot of that is this is the disadvantage of an appellate court when we're reading a transcript versus seeing someone testify and as a trial judge being able to, make those determinations of credibility and weight of evidence and to make that evaluation as to this evidence. And so with the trial court making the finding, like I said, that there was the lack of that, isn't that really an evaluation? The trial court's evaluation of the evidence put on by these witnesses and how they perceived it. I mean, how do we get around that?
Well, I don't think the court needs to get around it. I mean, the trial court simply had insufficient evidence to make a conclusion as to whether this was a true threat or not.
So you're saying there has to be something else, and I think that's what Judge Gore was asking. So what would the something else be? And obviously, it could be a lot of things.
Yes, and so the something else would be the rest of the context. And like if these students had been standing in the hallway and could testify as to what the conversation was, and I think it's important to note that there is a single set of words here that's all that the state has to rely on. And we do not know in what context it was said at all, other than that it was outside this classroom. And regardless of how these students, who Daniel apparently could not even see, took that, whether, one, it was objectively threatening, and two, whether he was being reckless by making this statement, can't be judged based on that. You need more. And let me talk about what the more could look like, okay? Because I think that's what we're getting into here. So let's say, if you look at the state cited a few cases from other states trying to show how this cases where it's been found. One was this D.R.F case from New Jersey. In that case, there were multiple witnesses to whom the defendant at different times had mentioned plans, statements that they intended to do it, and people began to take it seriously because they knew that this was not just a single statement about shooting the school, but there was some planning there. In the In Re MJS case, which was from Minnesota, it was bomb threats that were written around the school in the weeks after the school had twice been evacuated for bomb threats. And the defendant was seen writing this. So we know that this was, at least with a reckless disregard for whether it would be seen as threatening, because the school that had just happened at the school. And this was written where anyone could see it. The MR case from New Jersey, there was also the juvenile in that case was making statements that he hated everyone at school and wanted to destroy it, was talking about being upset, and I believe there was a breakup at issue in there and wanting to hurt a particular teacher. So if you take it into this case, there's all the things we don't know, and this is why you have to guess. This conversation could have been like one of these. There could have been talk about, I want to kill myself, and I'm really angry at the teachers, and now I want to bomb the school. It could be that the statement before that was, you know, we're having meatloaf for lunch today. Oh, I want to shoot up the school. And those are completely different. As are, you know, any range of possibilities as to what could be discussed
So
afterward.
what then do we do with the evidence that there had at least been some form of alleged prior threat to another student made by the juvenile in this case? I mean, doesn't that help? Doesn't that add to the layer of context with this?
It doesn't really add much in this. I mean, what was put on about that was that at some point in the past, he made a video about this particular student. Again, there's nothing to say that it was, you know, there's nothing, first of all, to make it more likely that he was really going to carry out any other kind of threat. I mean, past threats sometimes are used to say, like in Raise EP, we know this is somebody who just makes threats. Again, we weren't given very much about that, I think enough to make much of anything about it. I mean, certainly it can play in, but the state needs something about the state. I mean, this is a prosecution based on words. I mean, so we need to, and the First Amendment is very protective of words when it comes to criminal prosecution. So the state has to show that this is really a true threat, that this is a threat, both, you know, within the meaning of our statute and within the meaning of the First Amendment to go forward, and that requires some evidence. The state did not identify or
Is it
put on.
not some evidence of subjective intent, whether under a recklessness standard or anything that, you know, you've got somebody who knows what they're doing in making a threat? Maybe the broader question is, why isn't that just a question of the weight to be given to this evidence rather than the legal force of it?
Well, there's not enough to connect that to this. I mean, I think that really the deficiency of the evidence about this threat is what makes that evidence so unhelpful. It's not as though there was some similarities that were brought out, or it was clear that he was threatening a particular student, or that it related in any way to this past dispute with this other student that led to the video. It's just a statement. I think it does go to why that particular student felt afraid or felt, you know, it was more serious and reported it. And again, there's nothing wrong with the idea that the students heard this, took it seriously enough to report it to the school resource officer. The question is, what happens then? I mean, if the school's going to doesn't want people making comments like this that are inappropriate in school, you know, the school can certainly investigate that and take any kind of action. The question here is, can the state then move on to a prosecution based on what was said without pulling in anything else from that investigation? I mean, they did not even identify any of the other speakers, even though this was a class of 15 students outside the choir hall. They apparently didn't know who anyone else was, even though they're their classmates. Couldn't say what anyone else's reaction was specifically.
So I guess, Counselor, when you say not knowing what anyone else's reaction, how do you address, you know, a student who did testify, and in the transcript that testified that it, how did you feel when you heard, how did that make you feel? Said it made me sick to my stomach. What do you mean, sick to my stomach? You know, and the context seems to be sick to my stomach with fear. So when we talk about the objectivity of it, how do you get around the state hearing, okay, this statement, you know, could have been carried out. It rose to the level of creating fear within listeners. How does that not get to a true threat when you have the objectivity of a student saying it physically made them sick to their stomach, feeling with fear?
Well, I don't think there's any need to get around how that student felt about the statement. I mean, we're trying to get to Daniel's intent.
But doesn't that get to the objectivity and whether it's a true threat if it creates fear within the listener?
The factors that I mentioned from Watts are not just about the subjective intent. Those are about whether it's objectively threatening. And objectively threatening is also where things fell apart in Raise EP. because the context provided that a person hearing this and understanding the conversation would not really regard this as a true threat. And again, we're looking, we're prosecuting the speaker of the alleged threat here, and it's that person's intent. All of the witnesses testified that they couldn't see his face, didn't hear other words of the conversation, weren't part of it, and didn't know what else came before or after. Certainly, it may be reasonable that those isolated words, someone hearing them, a high school student today would take them seriously enough to report it to the school.
Let me ask you this, Counselor, and this is just an analogy. Judge Gore is big on analogies.
Sure.
Do you have to see a sniper for a sniper to be a threat?
No.
So, using your context, they didn't see his face. Why would having to see his face to get his expression have to be a factor for the state to have to use in being able to bring a criminal prosecution?
Well, it's not that seeing his face is an independent factor, but that's just one piece of how there's just nothing here.
Yes.
I mean, there is no.
And I've been peppering you with more questions than other, and you're into your rebuttal time, and Judge Stroud, I'm fine since I've been asking more questions, giving him more time. That's up to you.
Yeah, I'll let him finish that answer.
And now I've lost my thought for a moment.
I apologize.
That's all right. That's all right.
I didn't want you to lose your time. The facial expression.
It's one piece of what's missing. I would say that it's that.
Okay.
And with that, I'll reserve my time.
All right,
Thank you.
Good morning. May it please the court. My name is Lindsay Smith. I'm with the Attorney General's office, and I represent the state in this appeal. Your Honors, as we've already been discussing this morning, at its heart, this case is really about whether a young man who talks about shooting up his school while at school and in the presence of his peers can be held responsible for his actions. Now, the main sort of argument here that the juvenile has been making, at least this morning, is that the First Amendment bars his adjudication under the school threats statute. I'm going to talk about a couple of different reasons that that's incorrect, but what I do want to do first is just clarify and reiterate the standard here. As this court knows, there is no abstract question of law that this court needs to decide today. That's already been decided by our Supreme Court in State v. Taylor, as well as the United States Supreme Court in Counterman v. Colorado. And so the legal standard here is very clear. A true threat is a statement that is both objectively and subjectively threatening, and it is not protected by the First Amendment. And both Taylor and Counterman clarified that a subjective analysis is required. Now, on that subjective analysis, I do want to dig in a little bit into the recklessness standard that Counterman articulated, right? Because I don't know that we really got the specific statements from Counterman. And what the majority in Counterman said is that the recklessness standard involves insufficient concern with risk. And it means that the speaker is aware that others could regard his statements as threatening violence and delivers them anyway, right? Now, Mr. Corella has conceded, and I don't think there's any question here, that this recklessness standard is a different standard than the one that was articulated by our Supreme Court in Taylor. It is a different subjective standard, but on this constitutional question, Counterman does control this court's analysis. So, what I want to do is talk a little bit about both the objective standard that we've spent some time discussing already, and then turn to that subjective standard. And I want to parse those out a little bit because I think it's easy to get lost in merging those two standards together. And I think if we parse them out, Your Honors, it becomes clear why the state's evidence here was sufficient on both of these standards. So first of all, Taylor did articulate and reiterated these factors and these considerations that courts look at in determining whether a statement was objectively threatening. The context in which the statement was made, the nature of the language which was deployed, as well as the reaction of listeners upon hearing the statement. Now, we've talked a lot about context here, and I want to turn to that first because I do think it's very important, right? Now, Mr. Corella and the juvenile here have argued that there's no context here because there's no evidence about whether what the response was of the students to whom this juvenile was actually making his statement, right? Well, what I would say is we do have quite a bit of context here. We have a general context about the atmosphere in which students and high school students go to school today, particularly in the culture and this generation of school shootings that these students have come up through and are very much aware of. We also have a more specific context of this particular student and the interactions that these students have had with this student in the past.
I guess, Counselor, and not disagreeing with the climate of the overarching issues plaguing, schools and school shootings, that's hard to pinpoint into the specific facts of this case, and obviously can't be controlling. It's more of a policy argument. What specifically around the facts of this particular case are controlling to guide us to the standard at which you're arguing should be applied today? Because I'm not disagreeing with the macro, but get us to the micro of the facts centered around this case, because that's what's the most important to this juvenile, saying, well, hey, these facts shouldn't apply because you don't have enough here. Get us there.
Sure, Your Honor. Now, I will get to that question absolutely, and I think part of the general context does go to the micro, because you have 3 students who testified to their fear about hearing this statement, right? You have a student that said it was very scary because of all of these school shootings, and you never know what can happen at any minute. You have another student who said, I don't want to be in the next school to get shot up. And I think that is very relevant to the context here. And in fact, we've cited some cases in our briefs, including one of a panel from this court, that have talked about the importance of taking into consideration the overall political and cultural context. I mean, the Benham case that a panel of this court decided, where the court looked at, the defendant had disseminated wanted posters with an abortion doctor's face and information on it. And there the court found it very relevant that those types of posters and this general cultural context around abortion and particularly violence against abortion doctors was very relevant as to whether that statement was objectively threatening, and where a reasonable doctor would feel objectively threatened by seeing those statements. I think it's very similar here, right? You have 3 students who were afraid because of this statement because of this general cultural atmosphere of school shootings, and I think that's relevant to whether a reasonable student on hearing this statement would be afraid.
All right, so let's take that to the next logical. That's why I'm wanting you to get it here.
Yes, sir.
And I try to feed folks out of the same trough. The D.C. sniper that was shooting folks at gas stations outside of D.C. and through the tailgate of the vehicle. Do you stop going and gassing up your car just because that's happening in D.C. and North Carolina? I understand your argument, not turning a blind eye, but we have to look at the law as it applies to this defendant as it pertains to the individual liberties and rights, protecting the overall rights of victims, but get me to how, because we can't use generalized fear, right, in applying to the specific fear needed to evaluate the standard in this case. So not disagreeing with the argument, but I don't know how controlling generalized fear can be when we're looking at the individual, standard that the state is held to prove this defendant created fear. So not disagreeing with it. However, I don't know how controlling that can be from a generalized standpoint when we need the state to prove the specific fear that's generated from this defendant.
Sure. So I think a couple of other pieces to take into consideration here. I think the first is the language that this student used, right? I mean, that's one of the pieces of evidence that, or one of the factors. And I do want to point out, or at least distinguish the Watts case a little bit. That's the case where the young man was at a political rally and made the statement about, specifically the statement was, you know, if he had been drafted, or he got in his draft card, he said, if they put a gun in my hand, the first person in my sights is going to be LBJ, right? And one of the things that the court found very relevant there as to why that statement was not a true threat was because it was a conditional statement, right? He said, this is something that's likely not going to happen. You know, this is a student who has conditioned this statement, on this event happening. Of course, we don't have that here, right? We have no conditional statement. I would also point out that in Watts, the context there was a political rally. This is politically dissident speech, and that often comes up in these true threat cases, right, where you have, individuals who are, making statements that may have elements of violence to them in the context of political dissidence. We certainly do not have that here. We don't have any indication that this was a student who was making some kind of...
Well, how do we not know that?
Well, we don't have any testimony about...
And the burden's on the state to prove this beyond a reasonable doubt, isn't that right?
That is correct, Your Honor.
So I think what your colleague has been arguing is that there's some responsibility or obligation on the part of the state to actually then show the context in which this statement was being made, and not just rely on a statement in isolation and a few students who happened to overhear it or hear a snippet of whatever conversation was going on. That the state has a greater burden to prove some context here to hit that objective standard.
So I think a couple of points I'd like to make to that, Your Honor. I think the first is I don't know that the state necessarily has a burden to provide the specific, context of the specific conversation. I think the state has a burden, at least on the objective standard, to show whether a reasonable listener would feel threatened, right? I think that's the standard that we have here, right? And what we have here is we have 3 students testifying to their fear on hearing the statement. Now, yes, that's their subjective fear, but I think if you have 3 students who are testifying about that, I think that goes to whether a reasonable student would be afraid upon hearing this statement. I think that goes to one of the 3 factors that is articulated in Taylor, right? We look at, what was the reaction of listeners on hearing this statement? And this is actually where, this is the second point I want to make, Your Honor, this is where this case is very distinguishable from In Re ZP, right? Which is a very similar case. In fact, it's similar in that we have a student who says, I'm gonna bomb the school, or I'm gonna blow up the school, and then you have 3 listeners who are students. Not necessarily, there's no evidence in ZP that those were students that this particular student was making the statement to, but these again are 3 listeners. But that's kind of where the similarity ends, right? And what we have there is we have 3 students who testified, we didn't take this student seriously. One student said, I thought it was a joke, The other 2 students said, yeah, I didn't really think this was something to be taken seriously. That is very different from the scenario that we have here, where we have 3 students who are saying, yes, in fact, we did take this seriously. And one of the reasons we took this seriously, or at least for one student, was that this particular juvenile had made a statement in the past, or had made this video in the past about this specific student who overheard the statement that he was going to blow this student and other students' brains out. So I do think that's very relevant, right, as to whether a reasonable listener would feel threatened by this statement or feel that this statement was a threat. And that's going to that objective standard, right?
Was there any evidence as to sort of a temporal link between that prior threat and this statement, or any kind of other link other than it was made to this particular?
No, Your Honor. There's no evidence of that. But I do think, I don't think there has to be that temporal link, right? Because again, what we're looking at generally is, we're putting ourselves in the sort of reasonable listener position here. And the question is whether, a reasonable student here would have felt threatened or felt that this statement was threatening. And I think that's very relevant, right? It's when we have a particular student who has been the target of threats by this juvenile in the past, as to whether that student would feel afraid by a statement like this. And I think I want to go, I want to back up a little bit on the standard, just to reiterate that, there is the state does not have the burden to prove, or does not have to prove, that the juvenile intended to threaten any students, nor that the juvenile intended to carry out the threat, right? One of the prohibitions against true threats, and the U.S. Supreme Court has articulated this multiple times, right, is to protect against the fear and the terror that comes from these threats and the disruption that causes, right? And so that's why we have, that's part of the reason we have this statute, right, is to protect students from the fear and the disruption that these types of threats cause when they are made, or these types of statements cause when they are made in the school environment. As well as, I think there's a subsidiary interest, right, in catching these statements, or these types of catching violent actions at the point of a threat, right? We don't, to your question earlier, Judge Gore, we don't want to let those kinds of actions go any longer. We want to make sure that we're nipping this in the bud. But again, that just kind of I just wanted to pull back and think about, at least the reason for this statute, but also the reason that we proscribe, and that the U.S. Supreme Court proscribes true threats from the protections of the First Amendment. I do want to talk a little bit more about the subjective test here, right? I think first, it's important to think about the language that Counterman used when articulating this subjective test. The question is whether the student had sufficient awareness that his statement could be taken as a threat, such that he acted recklessly by making that statement, right? So the speaker is aware that others could regard his statement as threatening violence and delivers them anyway. Now, as I think Judge Hampson rightfully acknowledged, we don't have direct testimony of the juvenile's intent, but of course that's not unusual. This is why it's black letter law that a defendant's mental state can be inferred from other evidence. There's really a couple of different pieces of evidence here that I think are useful and are critical in determining whether this particular juvenile had the reckless intent in order to satisfy the standard. I think the first has to do with the witness's own awareness, and I'll explain why I think this is relevant, right? The student witnesses, as we already talked about, they had this general awareness about this fear of school shootings. I think high school students in general go to school today with a fear of school shootings, and these specific students had this fear of school shootings. Now, I think the reason this is relevant is that these are all high school students who are around the same age as the juvenile defendant. They are in classes with him, and their thought processes and fears are informed by this current sort of paradigm of school shootings. And so I think it's a reasonable inference that this juvenile had that same level of awareness, right, about the school shootings and the types of statements, the types of the fear that can be engendered by these types of statements.
So you're making arguments and adding a lot of context and nuance and inference to your analysis, but here the trial court made specific findings of fact, and so to what extent are we sort of stuck with the trial court's findings of fact, and to what extent can we add your context and inferences to our analysis? Because although the trial court did make some specific findings of fact, they're not particularly robust.
Mm-hmm. So that's correct, Your Honor. I mean, under the standard of review, this is essentially a sufficiency of the evidence standard with an additional layer of independent review, right, because of the constitutional question. And so, yes, the trial court's finding of fact are, binding on this court, and this court cannot, draw, rewrite those findings or draw additional inferences. However, I would say that on the sufficiency of the evidence standard, all inferences are to be drawn in favor of the state, and the evidence is to be viewed in the light most favorable to state. And I think that's very important here, right, is to look at the evidence that the trial court, or at least the findings of fact that the trial court made, and to draw any additional inferences in the state's favor, Your Honor.
So on that same vein, is it that these findings of fact are, as the defendant argues, insufficient, or are they distinguishable between the generalized fear that you talk about?
I'm not sure I quite understand the question, Your Honor.
The defendant is arguing that they're not sufficient to carry the day. But how are we to look at the specific differences in some of the cases? Because the glaring one to me is the fact that you have prior conduct by the defendant, allegedly perpetrated on one of the witnesses, and that's not in the trial court transcript. It wasn't used as prior bad acts, but it seems to have been used of the conduct or the actions taken by the listener. So how is that distinguishable between the cases that we have right now?
So I think what you have here is you do have it in the evidence and witness testimony that this particular student, that one of the students was in fact the subject of a threat. So it wasn't, just part of the evidence that the court found later after the adjudication testimony. You did have this particular student, and I think that goes to the student's level of intent. I mean, I think this is a student who has in fact made statements like this before, scary statements, and so I think it's reasonable to infer that those statements, that he understands the consequences and the type of reaction that is going to be generated by those particular statements. I mean, I think also, one way to distinguish this case, particularly from ZP, is, again, we don't necessarily, I mean, I have talked about this sort of more generalized level of fear, but the reason that I'm talking about that is because these students themselves testified to their own specific fear, and that's very different than what we have in NRA ZP, right, where we have students testifying, I didn't really take the student seriously, I thought it was a joke, and here you have students who are specifically testifying to their own level of fear, and it is because of, hey, we have this awareness about school shootings. And so I think, again, that goes to this juvenile's, level of intent, right? Is that he, as a young person, as a young man who is in high school, has this level of awareness that these students could, or that these kinds of statements could engender fear among his peers should he find them. And so I think that's the most compelling evidence that the state has put on, and it's all in the witness testimony. And so I think to go back to the standard of review, Your Honor, this is a standard. It really is. I mean, what this court needs to determine is whether there was sufficient evidence to show whether this statement was a true threat by. It was an objectively threatening, and the student had the subjective intent to threaten. It's not a particularly demanding standard. Now, this court does have the obligation to review the entire record to ensure that the student's First Amendment rights are not being infringed. But I think what we can point to here as well is that we've got this fairly distinguishable language from some of the other cases that Mr. Corella has talked about here. This is not a statement that's being made, in the context of a political statement or political dissonant language.
But isn't the broader concern here that we're sort of shifting the burden back to the defendant to prove context? That, I mean, taken to its extreme, you seem to be articulating that all the state would have to put on is evidence that a student, overheard by other students, said something about shooting up a school. And now you seem to be articulating that then that's enough to get you past the motion to dismiss, that's the argument, and then the burden's on the defendant to prove context.
So I think that I understand your question, Your Honor. I think a couple of points there. I think the first is I don't think you simply have to have evidence that other students overheard the student say he shot up the school. I think what is very relevant and important here is the students' testimony themselves and their testimony to their fear at hearing this statement, right? I think that is very relevant. I think also is very relevant the reason for their fear, in part, is because of some of the past statements of this student, right? I think the other point, though, I want to acknowledge the concern is I don't think that the state is shifting the burden here. I mean, what I would say is the state doesn't necessarily have to anticipate every single defense that a defendant would raise potentially, and I would say here this was not raised, right? Or at least this implication that there was some other context, excuse me, that there was some other context here was never raised in the trial court. And I think, I do think it's very telling that was never raised in the trial court, that we don't have any testimony or evidence, by the student. Now, I don't think that means we're shifting the burden. I do think that the state has proven its case by providing sufficient evidence, in part because of the witness testimony here, right? But I do think it is very telling that we do not have any other evidence that to the extent that the student would like to say, hey, there was some context here that was missing, that was never provided, right? So, I don't want to say that we're shifting the burden to the student, but I do think it's relevant.
I guess the thing is, as in a lot of these cases, we don't know what we don't know. It might be that they did a very extensive investigation and none of the other students actually heard anything, and so they didn't have anything to offer. It might be that there were students who did hear something that would have been favorable to the defendant or would have been favorable to the state. But this is what we have to work with, which is, always the case, I guess. But you're saying that this is enough to get over the sufficiency standard, although that maybe there theoretically could have been more, or maybe not. There might not have been more, but this would be enough. That's
correct, Your Honor, is that the court has to look at the evidence we do have in the record. And based on the evidence we do have in the record, that is enough to get over the sufficiency standard. It's not simply one student heard this student say, I want to shoot up the school. Now, I will say, I do want to put at least underline the fact that it is a concerning statement, even if all we had was one student saying, I heard this student say, I want to shoot up the school. Now, again, I don't know, I don't know if that would be enough, but here we have more than that, right? We do have these students testifying not simply about, I heard this student say I shot up the school, but we were afraid because of this. And I think and again, that goes both to the objective test and the subjective test in order to show that this is a true threat, Your Honors.
Counsel, address for it, and the defendant didn't get a chance to address it. Judge Gore was peppering him with First Amendment questions. The issue that's raised by the defendant, and obviously I understand the state's position on it, but articulate your stance on the discretion of the secure custody post-adjudication or prior to disposition.
Sure, absolutely, Your Honor. I mean, the state's position on it is that this is not properly before the court. Because it was not noticed for appeal by the student as it should have been under.
It's part of the adjudication order.
I think it is mentioned in the adjudication order, but it's not. What I would say, it doesn't merge with the adjudication order. This is a separate order. It's not. The adjudication order is not dependent on that. And it's not, so these are two separate orders essentially, at least when the trial court made the order following the adjudication.
So the state makes two arguments on this point. One, that it was not preserved as part of the appeal, and two, that it's otherwise moot. And correct me if I'm wrong, but I didn't see any argument on the merits of the actual non-secure custody here.
That's correct. And you're not wrong, Your Honor. And the state concedes that the trial court's decision here was inappropriate. So the state's argument here is really that just under the rules of appellate procedure that this is not properly before this court.
Okay, and understanding the argument, obviously, but is it the state's position that if it was reviewed on the merit, that it was inappropriate based upon the lack of discretion? What's the state's position on the merits of it?
So, I mean, I think what we would say is, yes, this is an abuse of discretion standard, Your Honor. The continuance, there's two different statutes that really come into play here. I mean, you really have both the order of the continuance as well as the order of secured custody. The order of continuance, I think, is the more problematic order here, and that's simply because there's really only, except for certain specific instances, there's only an extraordinary cases that a continuance can be issued, and I think that's probably the problematic piece here, Your Honor.
Okay, and that understood, but is there anything in the record that would support the trial court's discretion in placement of secured custody? And I know we're pushing you to have to address it because you're trying to avoid it like the plague, but you know, just calling it out like it is. But is there anything in the record that gets the judge there to justify the secured placement?
So I think on the secured placement on the statute is the statute is pretty broad in allowing judges to. Which
is why I said the record. Because
that's correct.
We notice anything in the record that gets the trial judge there to grant and use that discretion for secure custody.
So what we have in the record, Your Honor, and this is not part of the testimony on adjudication, it's really in the colloquy between the trial counsel and the court, is we have that this is a student who is a high flyer. He's got more than 4 points, I believe, at least in the juvenile system, and so he's got a high level of offenses.
And had there been had there been custody, continued custody, in secured custody, post-petition, leading up and until the adjudication hearing?
I don't know if that's in the record, Your Honor. I don't believe so. My time is up.
Well, you can.
Well,
I'll give you a couple minutes to finish, since I'll give him a couple minutes also.
So I really, just for the reasons that we've discussed, Your Honors, the state asks that this court uphold the adjudication of this student under the school threat statute. Thank you.
Thank you.
Thank you, Your Honors. I just want to go back directly to the record for a second, because I want to clarify something and just go to what was there. Okay, so first of all, there were 3 witnesses. Only 2 of them heard Daniel at all. One of them, quote on page 5, said that he was going to shoot up the school. That's the testimony. The second one on page 14 says he said that they was going to shoot up the school. The prosecutor then asks, and do you know who he communicated that to? No, sir. The Constitution requires more evidence than this in any setting, and it is the state's burden to put on this context and not to ask the defendant to put it on. But this burden is particularly appropriate in a school setting. The Supreme Court wrote in Shelton v. Tucker that the vigilant protection of constitutional freedoms is nowhere more vital than in the community of American schools. And the Fourth Circuit in the Starbuck case, which was about silencing student speech about a school shooting, merely because it communicates controversial or upsetting ideas, that silencing this speech would be incompatible with the very purpose of public education. Counterman and other cases talk in a general way about breathing space for the First Amendment around all of these areas of unprotected speech. The state's prosecution of Daniel without evidence of a true threat denied him that breathing space, as well as the opportunity to learn and make mistakes like any other high school student. This court should vacate the unconstitutional adjudication and disposition. In terms of the other issues in this case, I would just say on issue 3 that I addressed in the reply brief the state's notice of appeal argument. I think it is not supportable that a separate notice of appeal would be required to challenge a continuance between the adjudication and disposition any more than it would be required in a criminal case or in the cases where this court has previously reviewed that issue. So the response to that is in the reply brief. I won't go into it at length here. And unless there are further questions, thank you, Your Honor.
Thank you very much for your arguments. And we will adjourn.
Nice meeting you too. We also have Calderon.
We do. We do. Yeah, I know. We're going to be seeing a lot of each other, aren't we?
Yes.